Thank you for joining us. We are going to get started in about 1 minute.
Welcome, everybody. We'll start in just another 30 seconds or so. All right, I think we will go ahead and get started. Thank you, everybody, for being here with us this late afternoon or whatever time zone you're in, and welcome. I'm Jennifer Mnookin. I have the good luck to be Dean here at UCLA School of Law, and I want to thank you for joining us for this year's installment of our really beloved and annual series, Whither the Court, the Alan LeBeau Annual Supreme Court Review. I want to acknowledge first that UCLA sits on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. As a land-grant institution, we pay our respects to the ancestors, elders, and relatives, past, present, and emerging. Now, this is the 20th edition of our Whither the Court, our annual review of some of the major trends and cases before the Supreme Court. And it's really our pleasure to be able to offer what is invariably an insightful and fun to listen to and think about presentation each year. And we've been able to keep this tradition going strong, even in this virtual setting. Although I do think that this is an event that we look forward to being able to bring back to our beautiful campus as well. We're also really pleased and honored to be able to continue honoring Alan LeBeau. Alan was a really, truly outstanding member of the UCLA Law class of 1972. He was a leading corporate and bankruptcy attorney, and he is still remembered extremely fondly by his colleagues and classmates. He was a brilliant lawyer and a very good man. And this event, which is family endowed in his memory, is a terrific annual tribute to him. We thank them for their very generous support. And I also want to deliver a particular word of thanks to Cindy LeBeau for her ongoing dedication to UCLA Law School, to UCLA in general. And so thank you, Cindy. I think it goes almost without saying that those of us who teach and write about the law pay close attention to the work and the impact of the Supreme Court. And the forthcoming term will, I think, be exceptionally important. There's a lot at issue, a lot on the table. It's also the first full term with the court's new composition following the addition of Justice Amy Coney Barrett. Last term, the court shifted for the first time in generations to having a quite solid majority on one side of the political spectrum. And the ramifications of that development likely played into the event this summer, including when through its so-called shadow docket, the justices opted not to put a hold on the Texas abortion ban. I know today's panel will talk about the shadow docket and perhaps this case and certainly more, including a preview of what's ahead. As you may know, the forthcoming term includes a potentially landmark abortion case, Dobbs versus Jackson Women's Health Organization. It includes the court's first major gun rights case in a number of years, New York State Rifle and Pistol Association versus Bruin, and much, much more. I will also note that one case this term, FBI versus Fazaga, will be argued on November 8th by UCLA's Law School's own Ahilan Arulanantham, who is on today's panel. So that's also exciting to share. So that lets me turn to today's panel, and they have so much to discuss at this historic moment. So I'm going to introduce them, but very briefly. First, I want to introduce a very special guest, Melissa Murray. She is the Frederick I. and Grace Stokes Professor of Law at NYU School of Law and a nationally renowned authority in family law, constitutional law, and reproductive rights. She's faculty director of the Birnbaum Women's Leadership Network at NYU and co-host of the popular Strict Scrutiny podcast. And she is certainly among the country's most important voices on the actions and impact of the High Court. Melissa clerked for Justice Sotomayor back when Justice Sotomayor was a judge on the Second Circuit, which gives her added insight. I'm also very pleased that I got to serve alongside Melissa when she served as interim dean at Berkeley Law School. So it's truly a great pleasure to have her with us today. A big welcome to Melissa. The rest of our panel comes from our own UCLA Law faculty. We have Professor from Practice, Ahilan Arulanantham, who I mentioned earlier, and who is one of the nation's leading immigration law authorities and advocates, who's argued twice before the Supreme Court and will be arguing again this fall. He's been on the front lines of cases involving immigrants, refugees, asylum seekers, and a great many of whom have benefited tremendously from his efforts on their behalf. He joined us here at UCLA Law from the ACLU of Southern California earlier this year, and we're delighted to have him as a colleague and as our co-faculty director for our Center for Immigration Law and Policy. Professor Cary Franklin joined UCLA Law School this year as well from the University of Texas School of Law, and she has already established herself as a tremendous dynamic member of our community. She's a just phenomenal authority in constitutional law, anti-discrimination, and legal protections regarding sex, sexual orientation, gender identity, and race. She's the faculty director of our Williams Institute, which has been conducting cutting-edge research on sexual orientation and gender identity law and public policy for 2 decades now, and which we're very proud to have as part of the UCLA School of Law. And Cary also clerked for Justice Sotomayor when she was a judge on the Second Circuit. So a big welcome to Cary. Professor John Michaels is also joining us, and he's yet another brilliant member of our Con Law faculty here at UCLA Law School, a terrific scholar of administrative law, national security, the separation of powers, and much more. He's an award-winning writer and frequent media commentator on issues often at the center of the Supreme Court docket. And he brings his own views into how the court operates and deliberates from all of his time as a scholar, but also as a clerk on the Supreme Court for Justice Souter. John, thank you for joining the discussion today. Last, but certainly not least, we have Professor Adam Winkler with us. And Adam is also really the force who helps make Whither the Court happen every year and who helps organize this event. Adam, thank you for playing that role and congratulations on this 20th installment. Many of you joining us today probably also know Adam's work. He is also an exceptional scholar, and you may have seen one or many more of his appearances in the media as one of our top con law scholars. He's a go-to voice on the law surrounding the Second Amendment and gun rights. And his most recent book, We the Corporations, about the rights that corporations earned at the Supreme Court and elsewhere, was a National Book Award finalist, among many other awards that book received. So you have quite a group to listen to. It's really my enormous pleasure to be able to introduce you to all of them. And I know you're in for what will be a really interesting conversation about these terribly important issues. So let me turn this over to Adam and the panel. And again, to the audience, thanks for being with us. Take care.
Thank you so much, Dean Mnookin, and welcome all to Whither the Court. Of course, I'd like to begin by thanking all the people behind the scenes who made it happen, the people in our event staff and our alumni relations and our IT team, all for making this happen. They're operating behind closed doors and out of sight, but without them, of course, none of this would happen. And thanks to, of course, to all the panelists for participating today. As per tradition, all of the panelists are UCLA faculty, with the exception of our special guest, Professor Melissa Murray of NYU Law School. As Dean Mnuchin noted, Professor Murray is not only a renowned family law and constitutional law scholar, but one of the leading commentators on the Supreme Court. And if you're interested in the goings-on at the nation's highest court in the land, you simply have to listen to Professor Murray's incredibly insightful and entertaining podcast, Strict Scrutiny. I know I do, and in the little chat among the panelists before we went live, it seems that everyone else on the panel does too. So allow me also to express thanks to Cindy LeBeau and the LeBeau family for endowing this event. Cindy LeBeau teaches courses in the UCLA Political Science Department. And just yesterday, she shared with me that one of her students was, it turns out, one of the lead insurrectionists on January 6th at the Capitol. Her course, which was held remotely, began on January 10th, just a few days later, and he attended classes regularly, so much so that it was other students in the class who recognized him in videos of the insurrection and reported him to the FBI. So all I can say is I don't know how his academic transcript went as a result of that incident, but I certainly hope he was unable to take the final because he was in jail at the time. Certainly the Supreme Court is in many ways at a crossroads, making the question of whither the court especially appropriate at this moment. Just before last year's term began in October 2020, Justice Ruth Bader Ginsburg passed away, opening up a third seat on the Supreme Court to be filled by then President Donald Trump. The three new justices appointed overall by President Trump, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, portends significant change at the Supreme Court. Each of these justices had a distinctly conservative jurisprudence on the lower courts and can be coupled with the existing conservatives on the court. It can be expected to reshape the court and significant areas of constitutional doctrine. Last term, the Supreme Court decided 54 cases with signed opinions after briefing and oral argument. It's one of the smallest dockets in the history of the Supreme Court and the second fewest number of cases in 150 years. However, as we will discuss, the court also heard a number of important cases on what is known as the shadow docket, cases that are decided without the usual briefing and oral argument, and often decided without a written opinion. Indeed, in the shadow docket cases, we saw more division and disagreement than we saw in the ordinary cases over this past term. So tonight, we're going to discuss some of the big cases from the last term and forecast some of the big cases of the upcoming term, which begins on the first Monday in October. Last term, there were not that many high-profile blockbuster cases that made the front page of the news in the way we sometimes have come to expect with the Supreme Court. But the coming term seems certain to make up for it, with major cases coming down the pike on abortion rights, gun rights, and executive power. Last year's term reflected a Supreme Court that was beginning this transition. No longer is Chief Justice John Roberts the median justice on the court, and that position is now occupied by perhaps, it's a little ambiguous, but perhaps Brett Kavanaugh instead. There are 5 justices, it appears, to the right of Chief Justice John Roberts. So let us begin there. Professor Murray, you're our special guest. I'd love to begin with you. Is it fair to still call this the Roberts Court?
Well, first, Adam, thanks so much for having me. I have been an attendee at this in years past, and so I know what a glittering array of leading lights you have on this panel, so I'm absolutely honored to be a part of it, and many thanks to the LeBeau family for their support of UCLA and this event. As former dean of a UC law school, I'm always grateful when everyone steps up to support the work of public law schools, so thank you to them. So is this the Roberts Court any longer? I'm not sure that it is. And I will say that my views of this have really changed a lot over the course of the last few weeks. It is true that with the introduction of Justice Barrett, we were poised to see a real change in the dynamics of the court, but mostly in the ways in which people outside of One First Street perhaps regarded the court. And in some ways, we saw that almost immediately. A spate of ever more restrictive abortion laws being passed at the state level in anticipation of the view that they would find a more hospitable reception at the court. That happened almost immediately in October when she was appointed and formally took her seat. But I actually thought that the Chief Justice, although his influence might be somewhat diminished, would continue to wield a steady hand over this court. I think we saw some of that to some extent over the course of the last term. I think we saw a number of places, Fulton versus City of Philadelphia comes to mind, where the Chief Justice was a steadying influence insofar as he prevented the more conservative wing of the court from making a really maximalist decision on religious liberty grounds. But in the last few weeks, I think we have really seen the Chief Justice as a kind of lion in winter, which is to say that in that midnight ruling on Texas SB 8, in which the court, because of procedural irregularities, letting that Texas law that is flagrantly and obviously unconstitutional go into effect, we did not see the Chief Justice able to rein in the more conservative elements of the court. He's usually someone who can prevail upon his colleagues with institutionally minded arguments. Not sure that we saw that in that particular case. And so given the last few weeks, I think that maybe the Chief Justice is somewhat hobbled in his influence. This is not to say that he will be completely hobbled. He certainly has cards to play going forward into this term. If he joins the conservative wing of the court, forming a 5 or 6 person majority as the senior justice and as the Chief Justice, he'll have the prerogative to assign that opinion. And maybe that will be a way in which he manages to keep some control over the court's output. But again, that was such a consequential case that we saw being decided with such implications for what is coming down the pike this term in Dobbs, that the fact that the Chief Justice could not prevail on his colleagues to take a more limited route suggests that this is a court that may be out of his control.
It's going to be just really fascinating to see the way this goes, and to see, for a while we called it the Kennedy Court, and then we started calling it the Roberts Court. I'd be curious what we end up calling it in a few years' time. Maybe it's the Trump Court because of the 3 appointees that President Trump appointed to the court and their combined impact that they might have on constitutional law. We mentioned that this past term didn't have the usual number of huge blockbuster cases, but one very important case that Professor Murray mentioned was the Fulton case, Fulton versus City of Philadelphia. That case that arose in the context of the First Amendment and the intersection of religious liberty and LGBTQ rights. Professor Franklin, why was this case so significant?
I'll say at the end what I think about the size and scope of this ruling, but I'll just start by saying what this ruling was. So the City of Philadelphia contracts with private agencies in order to certify families in the foster care system. And one of the private agencies that is involved in this program is Catholic Social Services. The conflict arose because the City of Philadelphia has a fair practice ordinance, and it also inserts into its contracts with the private agencies a non-discrimination provision that covers sexual orientation. So if you want to contract with us and you do this work, you have to agree not to discriminate on the basis of sexual orientation. Well, Catholic Social Services says, we can't do that. We will not certify same-sex couples because in our view, that would be condoning these marriages, which we find illegitimate and destructive. So we believe we're constitutionally entitled to an exemption from that non-discrimination provision. For several decades, that would have been a non-starter. That would have been a bad claim. And it would have been a bad claim because we have a 1990 case on the book called Employment Division v. Smith. And what Smith said was, if you have a neutral, generally applicable law that applies to everybody and doesn't target any particular group, it's going to be reviewed under rational basis and survive. And you're just going to have to obey it. Well, conservatives have been gunning for Smith for some time now, and the hope was that Fulton would be the case in which the court overruled Smith, and that would have been a massive blockbuster. Maybe not overruling Roe, but it would have been a big deal. It would have made the headlines, and it would have been a big deal. That didn't happen because what the court said in Fulton is Smith doesn't apply in this case for 2 reasons. Small reason, we don't find that this Catholic Social Service agency is required to obey the Fair Practice Ordinance because it's not a public accommodation and only public accommodations have to obey Fair Practice Ordinance. So that's off the table. The bigger holding is that this non-discrimination provision in the contracts included an exception. It said the commissioner of the health department can grant exceptions at that person's discretion. At the commissioner's discretion, an exception may flow. The court said, even though, well, it didn't really acknowledge this, but I'll tell you two things about this. One, it's not clear at all that this exception even applied to the certification of families. And secondly, no exception in the history of this contractual arrangement had ever been granted. There were no exceptions that had ever been granted. But the court found the fact that exceptions could have been made meant that one had to flow to a religious objector, or that the refusal to grant the exception to the religious objector was going to be subject to strict scrutiny and almost certainly be found unconstitutional, as it was in this case. Okay, that was Fulton. It didn't get a ton of media coverage, and a lot of the coverage that it got said, in fact, I saw the word nothing burger twice applied to this case. It was a nothing burger. Smith didn't get overruled. There was a lot of hoopla about nothing. Well, let me tell you, it wasn't a nothing burger, because I think Smith is functionally overruled. Instead of holding that burdens on religious people are going to be subject to scrutiny, it kind of overruled Smith by taking a backdoor and not admitting it, by saying if a law has any exceptions at all, religious people are going to get what scholars often refer to as most favored nation status. They are going to be entitled to the exception. And there are so many, the vast majority of laws have some sort of exception in them. So here's one that scholars immediately brought up, which is Title VII exempts small businesses. If your business has fewer than 15 people, you do not have to obey Title VII. There you go. Our big civil rights era non-discrimination statute in the workplace has an exception. Does that mean now all religious employers can discriminate on the basis of race, of sex, of sexual orientation? Potentially so. This is not a nothing burger. This is a pretty significant decision. I'll just say two things by way of analysis. One, Catherine Franke at Columbia, who works on these issues a lot, has said something which I think is right, which is that what we're seeing is a tiering of constitutional rights. If you know anything about race and sex discrimination under the Constitution, you know that this is not how the court responds to claims of discrimination on the basis of race or sex, right? If you have neutral, generally applicable laws that happen to have a disparate impact on a racial group or on women, for instance, that's not going to be a constitutional problem. But now it is in the religious context. So Catherine says we have first tier rights, and maybe gun rights, Adam, maybe you would argue are now first tier rights, but certainly rights against racial discrimination and sex discrimination are second tier rights. And the other thing I want to say that's notable in conclusion about Fulton is that in a way it was a little anticlimactic, because the court had already done a lot of this work on its shadow docket in April before the merits case of Fulton came down. There was a case which some of you in California will know about, because it was a California case called Tandon v. Newsom, and it involved a COVID restriction that said you can't gather three or more than three households, families within your household. And the challenge was from religious celebrants who wanted to have services in their homes. The claim was you allow grocery stores, you allow pharmacies to be open. They have more than three households gathering. That's an exception. We get that exception too. We're entitled to it. You know, one of these midnight decisions without much reasoning, the court grants the exception and does this end run around Smith. It had kind of already happened. By the time Fulton came around, it just confirmed what the COVID cases had already sort of established, which is that Smith is functionally overruled and that religious rights have now become supreme over other kind of rights.
That's a great take on what's happening, that Smith was not overruled officially, but really through the back door with these exceptions, because every law really does. I think even the peyote law in Smith, it was a criminal law. It didn't have any exceptions built into it, but every criminal law is subject to prosecutorial discretion. Right. And so if there's any prosecutorial discretion, then that's the same kind of exemption as is provided by the city of Philadelphia in these contracts. It's very similar. Even if it's never been used, you imagine Smith coming out very differently had this reasoning been applicable. I think that I always, whenever I see these cases dealing with anti-discrimination law, I always wonder, like, would the court have reached these same decisions if the person who was discriminating was trying to discriminate on the basis of race? And it's hard to imagine that the court would stand at the sidelines if adoption agencies wanted to discriminate on the basis of race. It really shows that while the two forms of discrimination are not totally equal, part of the dilemma of today's law is that race discrimination is going to target or trigger the sort of skepticism and sympathy of the court in the way that we haven't seen LGBTQ rights quite as powerfully in that space.
I just follow up by saying one thing, which is one of the problems now is, I would say, we just don't know now what is going to be struck down, what is going to be an exception or not, because it's quite easy to say, oh, actually, this is not analogous to that. That exception isn't like this, to preserve the kind of thing the court wants to preserve and to get rid of. It allows a lot of subjectivity, potential for policy kind of decisions, and unpredictability, and all the kinds of things that we don't like in constitutional tests to come in.
Professor Arulanantham, you worked for the ACLU, and the issue of voting rights is, of course, an issue central to the work of that organization. Last term in Brnovich versus DNC, the Supreme Court made it harder to bring cases under Section 2 of the Voting Rights Act. This not long after the 2013 landmark decision that overturned another key provision of the Voting Rights Act in Shelby County. What happened in this case, and what does it portend for the future of voting rights litigation, especially in an era when we seem to see the enactment of so many voting restrictions in state after state?
Yes, thanks for the question, Adam. And yeah, I didn't work on voting rights litigation directly, except a couple of times, but I talked a lot to ACLU voting rights litigators at different stages of litigation, and have sort of followed the stuff keenly. I thought Brnovich was extraordinarily important, and it was another case that didn't get, I thought, the attention that it might have. It also came out after a lot of these takes about how moderate and institutionalist the court was. But this is a 6-3 decision, Justice Alito writing, Justice Kagan dissenting along the sort of partisan line that you flagged at the outset. I think it's really important both for what it does and also for the signals it sends, sort of like what what Cary was talking about. The case itself upholds 2 Arizona voting restrictions that are not particularly complicated to understand. The first one, if a voter votes in the wrong precinct, they throw out the vote. The vote is not counted at all. And it's sort of striking to think about how absurd that is. You could not count the vote for the local races, but still count it for statewide races and the presidency. And that's what a bunch of states do that have these rules, but that's not what Arizona does. And Arizona also throws out way more votes on the basis of them being in the wrong precinct than any other state by far. And they've switched them around a lot, apparently. So it is sometimes confusing to figure out where you're supposed to vote. The other rule was that if you vote by mail, vote early by mail, this rule made it a crime for any person other than a postal worker, an elections official, a caregiver, a family member, or a household member. So other than one of those people, to put in, give the ballot to drop it off the drop box for you. So you can't have a person who's going around the neighborhood and just collecting them all. If you live in a small place, or sorry, excuse me, in an urban center, or a place where there's a short distance to the voting box, it doesn't feel like a big deal. Where is it a big deal? in Arizona, it's a huge deal on Native American reservations. More than 80% of the people on Native American reservations in Arizona do not have home mail delivery, and a whole bunch of them are like an hour, 2 hours from the nearest site. It's also an issue in some Latino majority areas of Arizona. So the Democratic National Committee challenged this under Section 2 of the Voting Rights Act. As you had noted, Section 2, there weren't a ton of Section 2 challenges on cases like this prior to Shelby County, which, as you mentioned, in 2013, eliminated the pre-clear, or effectively eliminated the pre-clearance requirement for voting laws, and I think sort of sparked this whole era that we're living in now, which is very strange to people who lived prior to 2013, where you had all of these. I mean, sure, there was voting rights litigation, but you didn't have litigation over just sort of who has the right to vote and anything like what you see now in elections. Prior to that decision, Section 2 prohibits voting rules that result in a denial or abridgment of the right to vote on account of race. And it has a really interesting history. The statute was construed in a Supreme Court case, Mobile v. Bolden, to prohibit only voting rules that were enacted by discriminatory intent. So it was construed not to have a disparate impact component. And then in 1982, Congress overruled that. And President Reagan would have signed that, right, in 1982, and explicitly, added language that explicitly required disparate impact claims also to be cognizable under it. Under that statute, voting rules are prohibited if they result in elections that aren't equally open to participation by people of all races. In that, I'm quoting again, in that its members have less opportunity than other members of the electorate to elect their representatives. So it sounds really like a disparate impact statute, right? It's have less opportunity, equally open to participation. So all this language, it suggests it's just, it's a disparate impact statute. And that is not how the court reads it. In what to me feels like a real, textualism aside, pragmatism governs, under this definition of pragmatism, which is not, I think, what one would have to adopt. It feels very much like an anti kind of textualist opinion as you go through it. Basically, the court imposes a set of non-textual qualifiers that might make laws permissible, even if they do have a statistically significant disparate impact on the basis of race. The first one, if the rules that we're talking about are consistent with the usual burdens of voting, then they're okay, even if they have a disparate racial impact, which is not in the statute, but that's the rule. In addition, if a state has a lot of different ways to vote, like Arizona has early voting, not even by mail, right? Then that can excuse and make permissible a rule, even if that rule, again, has a disparate impact on the basis of race. It also strongly suggests that voting rules that were in place in 1982 when the law was enacted are okay because they're sort of part of the usual burden of voting. I mean, that feels very odd because obviously it's a sort of revolutionary law in 1965, and then they're overruling the limitation on it by the Supreme Court. But this is sort of saying like, no, basically, if it goes worse than 1982, that's a factor against it. But if it sort of is similar to what was already in place, we're not like trying to have a big revolution in voting laws here. And I found that very interesting for a bunch of reasons. One reason was because Justice Gorsuch, of course, is among the people who signed this. And just the prior term in Bostock, had read Title VII to prohibit discrimination against people on the basis of their transgender status, even knowing that, or sort of conceding that that's probably not what most people in Congress would have meant at the time. And yet he's signing this opinion, which is really, to me, saying sort of almost the opposite. Like don't look at the words as much as like look at what what would have sort of implicitly been intended in 1982. And then to me, maybe the most important thing about the case from a sort of voting rights, like sort of future voting laws challenges sort of standpoint is it rejects a narrow tailoring requirement. So the state doesn't have to explain why it didn't adopt another rule that could accomplish its same purpose, avoiding fraud or whatever they say is legitimate purpose, without having a disparate racial impact. Think back to what I said at the beginning about out of precinct votes. Like, why can't they just have a rule which allows you, if you vote in the wrong precinct, to just count your vote for president and Senate and just not count it for just those elections that would make a difference in that precinct? And that seems like it would accomplish the state's purposes and still, but have a narrower impact. And they don't care. It doesn't matter. And in the course of saying that, they really reject a large body of disparate impact law from Title VII, from the Fair Housing Act, and just say it sort of doesn't apply because we think this text is different. Just a couple of things. I mean, there's a very powerful dissent by Justice Kagan. I won't go through it all in the interest of time, but I really would encourage people to read it. It's incredible. It cites Frederick Douglass and kind of uses it in a way that is founding era history for the 15th Amendment, explains the history of Shelby County. It really feels like a warning call for our democracy in a way, that dissent. And then just two other really quick things I'll say. Justice Gorsuch and Thomas have this very short concurrence. It's like a paragraph. Which just says, no one has ever actually decided whether you can bring a lawsuit under Section 2. That is whether it establishes a cause of action at all. People have been suing on this thing for 50 years. Congress amended it in 1982 against the back, but that doesn't mean that the plain text of this language might actually not permit lawsuits at all. And they just sort of leave that hanging on there. I feel like a sort of like a telegram to people, states that want to pass restrictive laws and find a different theory to defend their laws. And then the very last thing I'll just say is Brnovich. It popped in my my newsfeed. Brnovich is the same. He's still the Attorney General of Arizona. He is actively attempting to undermine the results of the 2020 election in that Arizona audit thing that happened, and that found that there were more votes for Biden that should have been counted. He just sent a letter placing a litigation hold to preserve materials from the 2020 election to all the people who were responsible for it. Even though it found no sort of material shift in the results. I just think that's so telling of the signal that the whole thing sends, right? This is like a message saying, yes, you can do other restrictive voting laws. There's 6 justices here that are going to look very narrowly on Section 2 claims. And I think it's a very important and very problematic decision.
Can I add a little something about Brnovich? Brnovich was one of the cases that came out on the last day of the term. The other case that came out on the same day was Americans for Prosperity versus Bonta, which was a challenge to a California disclosure law that required contributors to charities to disclose their identities to the Secretary of State of California. The court in that case said that California's law could not be upheld based on First Amendment grounds, and the case is widely viewed as having strong implications for the prospect of campaign finance laws going forward. But I will just note that one of the rationales that California offered for the disclosure law was that it was trying to deal with the problem of fraud in philanthropic entities and charitable contributions. And the court didn't seem to buy this concern about fraud prevention when California offered it in support of that disclosure law. Contrast that to Justice Alito's discussion in Brnovich, where he, I think, apparently credits the big lie and the idea that voter fraud or electoral fraud is a rampant problem that states are authorized to take action to curb. And to be very clear, in the 2020 election, incidents of electoral fraud were glancingly rare, if at all. And that has been made clear throughout multiple audits, fraudits, if you will. But yet the court, I think, gave succor to the whole idea that this is something that is rampant and that states are obliged to deal with. But again, it was a very inconsistent treatment of state interests in fraud prevention. In Brnovich, it was quite well prioritized. In Bonta, not the same.
Well, I just wanted to jump in, and I'm glad Melissa brought up the big lie. I've been working on an article for the last year that argues that in the judicial realm, textualism and originalism is the big lie. It's the big lie for the coming generation in the judicial realm. And here's why. It purports to be objective and scientific and neutral, and just looks at the original public meaning of the words of the provisions and uses a dictionary and doesn't import judgment, policymaking, political preferences. And so all of these opinions that are coming down the pike that are reaffirming Republican Party policy choices are actually just arising neutrally from texts. And they just happen to coincide with FedSoc or Republican priorities. And one of the things that I've been looking at is how many, what I'm calling shadow decision points, are involved in applying textualism. So there are all of these shadow decision points when you're interpreting one of these statutes that don't get acknowledged at all by these judges. What language are you subjecting to the analysis? Are you using a dictionary? Are you using a linguistic database? What year are you looking at? There are about 100 shadow decision points. They're inconsistently applied. There's no guidelines. They're not even, the judges don't even acknowledge that they're making choices at all of these places. And they aren't methodological choices. They're policy-driven choices, but subsumed within this veneer of scientific jurisprudential choice. And I just want to respond to what people are saying and say, one of the biggest shadow decision points is, are we going to apply textualism at all? Because we got Justice Gorsuch saying, only the written word is law, Bostock, right? It's just textualism. And then he signs on to this wildly atextualist or anti-textualist decision in Brnovich, leaving behind that commitment to textualism apparently completely. And so if textualism can come in when it helps and doesn't come in when it doesn't, these claims to objectivity are just not that compelling.
I'll add on that. Completely agree with what you're saying, Cary. In the on-bank litigation, in the case that we'll talk about later, my case, Fazaga, the dissent interpreted the side that lost. The Judge Bumate, who's quite a conservative judge, interpreted the statute in part based on the nearest reasonable referent canon. And this is sort of one reason he gave for reading the Foreign Intelligence Surveillance Act the way he wanted. The statute is enacted in 1978. We did a massive search. There literally are no references in any case, published decision, to the nearest reasonable referent canon until 2012. There is no apparent application of it to any other. And it's just sort of cited like, here's the thing. This is how I read the statute. Look at this rule, grammatical rule. But why would you believe that people ever understood this rule and would have written sort of in keeping with it, like 40 years before anybody even mentioned it, but yeah, there's this sort of just uncritically adopted that way.
Great points about Brnovich and textualism, et cetera. Another area where we're seeing change in the Supreme Court, and we saw some inklings of it last term, is in administrative agencies, restricting the power of Congress to influence who gets appointed to such agencies and the deference that judges should owe to these administrative agencies when they interpret their statutes. This has been something that's been bubbling up through the surface, under the surface for some time. Professor Michaels, what happened on this front last term, and what does it suggest about the future of the administrative state and Congress's power in this space?
Sure, Adam. Can I just jump in and first make a quick point about your first question that Melissa took about the court, because I don't think they're unrelated about is this the Barrett court or is this the Roberts court? I might suggest there's a third candidate, and it's Justice Thomas's court. This is a position, these challenges that I'll get into, to the kind of fundamental cornerstones of what administrative governance and basically public administration in America has been for over a century. And he's been long advocating for the aggressive reconsideration of long settled precedents. He began doing this as just a lonely voice, often as a way out concurrence. And it was so way out when he started doing this in the 90s and the early 2000s that it was often an open question whether we would teach that concurrence at all, whether casebook editors would waste a half a page to include it. And we had to think long and hard about how much credence to lend it as well. And at that time, at least three of the current justices were quite junior lawyers. And during this past year, as we've talked about in particularly in the Fulton case, there's been an aggressive invalidation of democratic decision-making, disregarding public health officials, state and municipal legislators during a once-in-a-century pandemic. This is very much consonant with a populist discourse that's also surfacing at this particular moment. And I don't think there's any judge or justice in the country who is more closely associated with that kind of model of public engagement than someone like Justice Thomas, who kind of disdains and very publicly disdains the so-called elite. He doesn't spend his summers at Salzburg like Justice Kennedy did, or making the rounds by speaking along the Amtrak corridor, but he's an RV enthusiast who travels across middle America. And I think that's something we should not totally ignore. I mean, justices they have public personas, and how they present themselves, I think, is often relevant to what they're trying to convey. And lastly, the point about the shadow docket, if any judge has been more vocal about saying how wasteful oral arguments are than Justice Thomas, I haven't heard it. So I don't know behind the scenes if this is consistent with Justice Thomas's thinking that oral arguments is often a big waste of time. But it certainly wouldn't offend his sensibilities in the same way from someone who at least is publicly committed to hearing oral arguments and perhaps, being receptive to what might come out of those conversations. So I just wanted to kind of put that out there as well before we turn to the kind of nuts and bolts of administrative governance, which admittedly is not, this is where if we were a TV channel where people are quickly grabbing for their remote controls. But I'm gonna urge you to hang in there for this case, because it is quite important, and it reveals a lot. And so what Adam was referring to is a case called Yellen versus Collins. And it does involve the fairly esoteric question about the propriety of the position of the director of the Federal Housing Finance Agency, and specifically the statutory terms upon which that director might be removed. And what happened in the case is the court struck down the provision that Congress included, which restricted the president's ability to summarily remove that director. The majority insisted that such a restriction was incompatible with the president's unitary control over the executive branch. Now, this decision wasn't super surprising, because it followed closely on the heels of a case from a couple of terms ago in a case called Celia, where the court invalidated a similar restriction that insulated the director of the Consumer Financial Protection Bureau, which was a position also created in the aftermath of the 2008 global financial crisis, and insulated that director from summary dismissal as well. What Congress required was that there be a showing of good cause, meaning that the director could always be removed and replaced upon a showing of some kind of failure to carry out the agency's mission and follow the statutory directives. So if we pair these two cases together, I think we can actually glean a whole lot about how this court is thinking about Congress, about the executive branch, and how regulation in America ought to be designed, overseen, and carried out. And there's a couple of points I just want to quickly make about this. First is, when you read the opinion and you read the opinion in Celia Law, the majority's, a fairly stable majority at this point, is really adhering to a notion of Congress as a big bad bully and a threat to the president. And so it follows that efforts by Congress to restrict presidential control over personnel is in the what I think is inflammatory, but I think this has become more mainstream discourse among the conservative justices, is a threat to the liberty of the American people. And this notion is, I gleaned principally from some musings at the time of the founding about how they thought Congress would be better equipped to be dangerous. The problem is, of course, it's entirely divorced from the reality. And it's been a kind of long clung to, but ahistorical sense in which the president is weak and embattled, and therefore must continually be fortified at every turn. We're now in almost 100 years into the era of what's been referred to as the imperial presidency. And when I'm saying that, this isn't just my cranky take on Joe Biden or Donald Trump. It's an undeniable claim about the accretion of executive power under the likes, of course, of Biden and Trump, but also Obama, Bush, Clinton, Reagan, Nixon, Lyndon Johnson, and of course, dating back to Franklin Roosevelt. And this is, this restriction that Congress included, I think, is modest. And I think it's, if anything, laughably modest way for Congress to attempt to withhold some shred of power from these imperial presidents, to ask them, to suggest that they might have to articulate a substantive reason why a director of a secondary office. I mean, we're not talking about the Secretary of State. We're not talking about the Attorney General. We're not talking about who's running the Pentagon. Just a substantive reason why this person is incapable of advancing the department's mission. I just don't think that's much of a burden at all. Secondly, it's not clear now when we think about these cases together if there's any limiting principle here. So the Trump administration didn't defend the statute. So they appointed a lawyer who actually comes from academia, a BYU professor named Aaron Nielsen, and he argued the case on behalf of the federal the Housing Finance Agency. And he warned that if you eliminate the director's protections here, you, the court, there's no rational basis for protecting members of the career civil service working all the way across the federal bureaucracy. And what does that mean? What that means is that if he's right, if Aaron's right, we're veering in the direction of empowering presidents to go back to essentially a spoils system where they can remove personnel at will. And that includes climate scientists, pathologists, epidemiologists, career lawyers in the Justice Department, who particularly those who dare to speak hard and often politically unpopular truths. And I think that's a dangerous position that the court is walking us down that path. It's especially troubling after 4 years of a president who was foaming at the mouth to talk about deep state conspiracies within the Justice Department and the intelligence community. It's after a year plus of aggressive acts of intimidation targeting election officials, public health officials, and as we've seen most recently, school board members across the country. Now, of course, I'm talking about local officials, but there's no reason why federal officials wouldn't also find themselves in the crosshairs when they make controversial decisions. Again, for daring to speak true, to hold true to their convictions in the face of angry, forceful, and often numerically small groups of agitators. And it's a moment when we have vital need for nurturing the talent of climate scientists, public health officials, and experts on voting and racial and criminal justice. And if you're thinking about, whether your job has much security in it, maybe you don't go into government in the first place, or maybe you're looking and saying, hey, you know what, 2025 is not that far along. And as a committed believer in that climate change is an existential threat, maybe it's time for me to find a different job. And last, I would just say this is all engendering a bit of a self-fulfilling prophecy, because the more political, the less stable public administration is, the more likely it's going to be viewed and fairly viewed as less credible, effective, and legitimate. And so there's this spiraling effect of the more we attack administrative governance, the more we have reason to continue to attack administrative governance. And I'm not sure where that leads us.
That's great, Professor Michaels. And you mentioned Justice Thomas's criticism of oral argument in the Supreme Court. One of the interesting dynamics of the last term was how often Justice Thomas spoke. As some of you may know, he once went 10 years on the Supreme Court without asking any questions at oral argument. But the court adopted a new method, a new process for oral argument due to COVID. Oral argument was done telephonically, and instead of the old-fashioned free-for-all, the justices took turns in order of seniority. And one of the, I think, fascinating aspects of the past term was to hear Justice Thomas, who is the most senior member of the court other than the Chief Justice himself, asking questions. He went early on and asked questions in, I believe, every case that was argued telephonically this past year. So a totally different Justice Thomas we saw once we moved away from the free-for-all of a traditional oral argument. And I say every case, but I should say every case that was decided with oral argument. And as you've already gotten the feeling and sense from some of the things that have been said, there were a lot of cases decided on the shadow docket. And while some Supreme Court commentators said that this year, past term, there were a lot of sort of moderate cases, there weren't the big revolutionary cases that some people expected, there was a lot of dissension and disagreement in shadow docket cases among the justices, and important rulings that came on areas of voting rights, limiting some of the voting rights accommodations that were made in as a result of COVID, curbing curbside voting and curbing extended deadlines for absentee ballots. As Professor Franklin mentioned earlier, in the shadow docket cases, the court also rewrote significant portions of religious liberty law, allowing it much easier to make claims that the state is discriminating. I'm curious about what my panelists think about the growth of the shadow docket today, and and why that might be a troublesome way for the court to be deciding so many big high-profile cases.
Well, to be really clear, it's not as though the shadow docket was created out of whole cloth and just emerged this year. It has been a part of the court's operations for some time. It is a docket management tool that allows the court to deal with emergency appeals that have to be resolved quite quickly. But I think the reason why the shadow docket is emerging from the shadows and becoming a source of not only conversation, but also controversy is because it has also provided a way for the court to make decisions, to do so inconsistently. And a number of commentators have noted that the rise in activity on the shadow docket really stemmed from the Trump administration Solicitor General's use of the shadow docket to implement Trump policies by allowing the court to vacate nationwide injunctions that lower courts had issued on some of those policies. And so what has happened is that you had a lot of activity during the Trump administration, much of it in favor of the Trump administration. And now in a couple of very recent shadow docket cases, we've seen the return to Mexico policy re-implemented. We've seen the Biden administration's COVID moratorium gutted. And of course, we've seen SB 8. And I think all of that has given fuel to the view that the shadow docket has something nefarious going on. And I don't know that it has to necessarily be nefarious. Again, it is a means of resolving emergency petitions that the court has to hear quite expeditiously. But as you say, it is not an ideal place to be deciding and making substantive law or jurisprudence, because it is a series of cases that are decided without the benefit of full briefing and oral argument, and they are often decided without the kind of full disposition that you would expect of a case on the merits docket. So the kind of transparency that we would typically expect is just not present there. Like, we don't often know who was in the majority or who was in dissent in a shadow docket case unless the dissenters actually identify themselves. Usually these decisions are summary or they're decided per curiam, and you don't know who was in that majority. So the kind of transparency that we expect isn't typically there. And I think the other issue with the shadow docket, which really comes across in SB 8, and it's worth noting that today the Senate Judiciary Committee held a hearing on the shadow docket and the threat to reproductive rights, sort of twinning them together in large part because of SB 8. But what happened in SB 8 with the court allowing that Texas law to go into effect because of quote unquote procedural irregularities, a lot of conservatives said that that was a nothing burger. Like, of course the court had to do that because there was real questions about whether they were standing to sue those particular defendants in federal court. But I think what that argument belies is the fact that it was on the shadow docket and the fact that the court cited these procedural irregularities meant that they weren't actually dealing with something they could have dealt with, which was the fact that the Fifth Circuit had intervened to stay all of the lower court proceedings in that Texas case. And the reason there were procedural irregularities is because the district court hadn't been able to conduct a proper hearing. And so there actually was something that the court could have done. It could have vacated the Fifth Circuit stay and allowed those procedural irregularities to be resolved. And so the fact that they didn't, they cited these procedural irregularities and allowed this law that is flagrantly unconstitutional to go into effect, I think gives the view that they are using the shadow docket opportunistically and weaponizing it to institute policy choices that they favor and to ignore those that they don't.
Just really quickly, two other things about the shadow docket that struck me. You need 6 votes, right, for a summary reversal and also for an injunction. And so for the court to issue it, right? And so I think that you see a shift now. I know somebody else probably knows the numbers. I don't know exactly what the numbers are. It was like extraordinarily rare to see these in the past. Now there's been a lot of them since Justice Barrett joined the court, because now you've got that 6. And that's one way in which I think the difference from 6 to 5 is really extremely significant. The other thing, just from having, even before the first MPP ruling, also the Muslim ban ruling, I know this from a bunch of immigration cases, they issue these substantive rulings, like, as other panelists have mentioned, but then the case is still going up because they've granted cert. And so now you're briefing and trying to make these arguments for why they shouldn't do what they've already done in sort of, like 4 pages or 7 pages. And you're just sort of like dead man walking. It doesn't matter, like, they're really going to reverse themselves now and change their substantive ruling after they've done that. So that, the transparency and sort of process harm is really significant when I'd almost prefer if they didn't say anything when they issued those rulings from the standpoint of the litigators, because then, at least you'd have some, but otherwise it's just like the case is over, even though there's like 2 years more of litigation left. It's really, really awful.
So I guess I'll just jump in too to echo what people have said. And one of the things that I just wanted to give a little bit of texture to something that Melissa said about the inconsistency and pick up on what she was saying about the court's claim that it had to let SB 8, the Texas abortion ban, go into effect because it wasn't clear that there were procedural questions that needed to be resolved. It wasn't clear that the proper defendants were in court and that needs to be resolved before we can issue emergency relief. Well, that very question didn't trouble the court repeatedly in the COVID cases. So there were clear procedural irregularities and questions in those cases. There was a Roman Catholic diocese case where New York had put a limit on how many people could gather for religious services. And the rule was no longer in effect by the time the case got to the court, right? We had moved into one of that color-coded, we were now like in yellow, and it was safer and you could have more people. So there was a real question about whether we even had a case or controversy, whether the thing was moot, but that just didn't, the court ran right over that and just said, the harm that could result is so great that we have to intervene and stay this law, because you might have to listen to mass over Zoom as opposed to going to the church. And that is a serious irreparable harm. Oh, that may be, but compulsory pregnancy for 8 months and forced motherhood is arguably at least comparable to having to stay home and watch mass over Zoom. But that didn't come up in the Texas case. And I'll just cite once again, the Tandem v. Newsom case in California, where the court, under the All Writs Act, which is what it was using to grant this emergency writ, had made it very clear for decades that the law had to be indisputably clear before it would give a writ. The idea that it was indisputably clear that you get a religious exemption, if a grocery store gets an exemption, then you should be able to meet in your house. I would have thought it was indisputably clear the other way. The best I could say is that it was contested. It certainly was not indisputably clear in the way that the court was saying. So again and again and again, we've seen cases with procedural irregularities that don't seem to bother the court, except then when this abortion law comes up in Texas, all of a sudden they can't act. That's the kind of troubling inconsistency that we see on the shadow docket, and why people are saying, give us merits cases where we can argue about it, where you have to give reason, where you have to tell us what the rules are going to be so that we can apply them consistently from case to case. And all of that is falling by the wayside as the court decides these big controversial issues in one-liners, in a way journalists don't comprehend, not released in the ritualistic way of 10 a.m. we're all waiting, but midnight in a way that looks like nothing important was being done. I think regardless of your policy views, your politics, this should be troubling to you.
May I jump in with just one quick point as well? So just to go back to Melissa's points, the utility of the shadow docket, and I think the reason why it wasn't really, commonly called the shadow doctrine is because it didn't have any type of negative or troubling connotations. It was often it was a managerial tool, as Melissa said, for handling the misapplication of clearly established law. So it was about error correction, and almost entirely about error correction. And in fact, not too long ago, it was the conservative jurist who railed against the overuse of summary reversals of that sort on the grounds that this was, oh, these are kind of bleeding heart, poor, woe, poor is me, aggrieved petitioner cases, and we shouldn't be wasting our very valuable time. Or if we are, we should devote the adequate resources that we otherwise would attend to these matters. But it was often because some, some misapplication of the law that really injured someone, presumably who had subpar lawyering on the way through the state or usually the state court system. And it's just radically different from what we're seeing today.
Several of our panelists have talked about SB 8 and the Texas law that was decided on the shadow docket. That case sort of portends trouble ahead, I think, for the right to choose abortion under the constitutional doctrine of this current court. The court has agreed to hear a major case that's going to directly consider the question about whether the viability principle embraced by Roe versus Wade and Planned Parenthood versus Casey remains good law and really effectively overturn Roe versus Wade. That's a case that comes out of Mississippi. Professor Murray, I know you're following the case very closely, as we all are, really. Why is this the most important abortion rights case in decades?
Well, I think this is a case where you really do see yet another impact of the shift from 5 to 6. And so just by way of explanation, when Mississippi filed for certiorari now over a year ago, its claims to the court were actually quite modest. It suggested that this was not a case that would put Roe or Casey in the crosshairs. This was simply a question about what the scope of the undue burden standard would tolerate or permit, whether viability would be maintained as a salient marker in the court's jurisprudence. I mean, again, very modest requests of the court. That was back in May of 2020. Fast forward to today, post Justice Barrett joining the court, Mississippi is taking a much more assertive posture with regard to this case. And so in its first brief before the court, Mississippi has explicitly invited the court to overrule Roe and Casey. So, what a difference a year makes. And I think that really sums up why this is likely to be the most consequential abortion case since 1992's Planned Parenthood versus Casey. This is a case that puts the question of Roe's longevity squarely on the table. And not only is it squarely on the table, this is a situation, perhaps more so than was the case in 1992, where the change in the court's personnel really augurs a true shift in the jurisprudence. We have 3 members of the court who were expressly selected for their seats by a president who vowed to appoint justices who would overrule Roe and Casey. And again, there is a 6-3 conservative supermajority on the court. So all of that does not necessarily augur well. I think the fact of SB 8 also suggests that there are at least 5 people on the court who are willing to go to the mattresses on abortion rights, even to the point where they will deprive those citizens living in one of the most populous states in the union of their constitutional rights for some period of time until the constitutionality of that law can be resolved once and for all. So, this is a court, I think, that is prepared to do the most on abortion rights. The only limiting principle, as far as I can tell, is the fact that this case will be argued on December 1st of 2020. It will likely be decided in June of 2021. And in just a few months after that, Americans will be marching to the polls to vote in the midterm election, where it is very likely that control of both houses of Congress will also be on the table. And although John Roberts has expressed great skepticism, if not antipathy, for abortion rights over the years, he is first and foremost, I think, an institutionalist on the court. And I can't imagine that he feels comfortable with the idea of millions of American women marching to the polls with Roe's death on their lips. So, what I thought before SB 8 was that he would try to broker some kind of compromise where maybe they eliminated viability as a salient marker in the court's jurisprudence, but allowed Roe to nominally stand and then allowed the midterm election to happen and then faced off in another abortion challenge. And there's always another abortion challenge coming down the pike. After SB 8, I don't know if he has control of the court to be able to broker that kind of compromise, or if the hardcore conservative wing of the court really is in ascendance here and will be able to have its way. It certainly had its way with SB 8.
I heard it said somewhere that one of the programs about the Dobbs case that's coming out of Mississippi that you've been talking about, that the court seems likely to overturn Roe versus Wade in its entirety or kill it by 1,000 cuts, and that the kill it by 1,000 cuts would be very vicious wounds and not really small ones. And one questions whether Roe versus Wade survives in any way, shape, or form as a result of this case.
Well, to be really clear, the death by 1,000 cuts strategy has been in play since 1992 with Casey. I mean, the abortion right for many women in this country, particularly those who are poor or who live in rural areas or who don't have access to adequate medical care, for them, Roe is essentially a nullity in many ways. So we've already gotten to that point. I think the real question here is it going to be eviscerated as a formal matter, or will it sort of hobble along for a couple of years afterwards? And I almost think that maybe the explicit overruling might be preferable, because it would at least avoid people in the media trumpeting that Roe has been saved, when that is in fact not at all what has happened. And we saw that in 2020 with June Medical Services. You know, Roe has been saved, abortion has been saved, when in fact, Chief Justice John Roberts, in the name of stare decisis, utterly gutted an existing precedent on abortion.
It's very powerful. One of the things that's really nice about this panel that we have together is not only do we have great experts on things like reproductive rights, like Professor Murray and Professor Franklin, but we have Professor Arulanantham, who has got 2 cases before the Supreme Court this very term. Including one he's going to argue, the Fazaga case. Do you want to tell us a little bit about these cases and why they are so important?
Sure, and I'll try and keep it brief because I know we don't have a ton of time left. And also try and keep in my head that oral argument isn't necessarily a big waste of time. It might actually make a difference, at least in some cases. But yeah, Fazaga is my case. I've litigated it for more than 10 years. The central question in Fazaga is whether the state secrets privilege permits the court to dismiss our claims that the FBI engaged in electronic surveillance of our clients on the basis of their religion, targeting them because they are Americans who practice Islam, where the government claims it needs the secret evidence to defend itself. So that's, the government says, we have evidence to show that we didn't actually surveil people because they were Muslim, but it's all secret and we can't show that even to the court ex parte and in camera, and therefore the case has to be dismissed, right? Or if instead, because it is a case involving electronic surveillance, do the provisions of the Foreign Intelligence Surveillance Act apply? And under those provisions, the government has to give secret evidence to the court for an ex parte and in camera review, and the court decides that the surveillance was lawful. So that's sort of the central question presented. I saw a question in the chat about whether, do any religions other than Christianity ever win? We'll find out maybe. Although I will note, I have some hope from the fact that there was a case Tanzan v. Tanvir from I think a couple terms ago, where some Muslim Americans who were put on the no-fly list by the FBI because they refused to become informants, won at least that they had the right to bring claims under the RFRA. So I don't think it's impossible. Certainly, if I were betting on, I'm not sure. Well, but I better not even say anything about that. but you have to sort of believe that you've got a shot, and I do believe that we have a shot. And the case itself arises out of really extensive surveillance by the FBI of Muslim Americans. It started, after 9/11, and has never really stopped. And our clients, Yasser Fazaga he's an imam. It was at a very prominent mosque in Mission Viejo. The 2 other people were congregates in another, mosque in Irvine, and they were subjected, like a lot of people, to random FBI interrogations, intrusive questioning, people coming to visit them. We filed a FOIA to try and learn a lot about this stuff. There's tons of FBI surveillance in the Muslim communities all throughout the country, that was really troubling to people, and it now has become sort of normalized. We learned some things that probably wouldn't have been enough to file a lawsuit by itself. But then there was this informant, a person who the FBI had paid to go into mosques in the same Southern California area. And he was trying really hard to incite violence. He met all of our clients. He gathered tons of information about people. And then they got scared of him and reported him to the FBI. And then, after that, the FBI sort of discontinued use of him. And then he got really upset and he went public and disclosed that he had been working for the FBI, that they had instructed him to target people because of their religion, to focus on people who were more devout, who were sort of going to prayer early morning and late at night, or who were like wearing long beards and changing their clothing. I mean, just very clear allegations of religious discrimination. And so sort of on the basis of the information that we had before, but in particular, very importantly, the information from this informant who's sort of akin to, I would think, like a whistleblower, really. We brought a lawsuit, we brought a bunch of claims, religious discrimination claims, also Fourth Amendment claims that I won't sort of get into now. And we sought the destruction of all, so the FBI to destroy all the records that were unlawfully obtained as a result of all the surveillance activity. And then the government said, as I said, they said, we don't target people solely because of their religion. And we can defend these things, but to do that, we'd have to give you secret evidence, and therefore we can't do that. And so all of your religion claims have to be dismissed. And the district court accepted that argument. We appealed that, and in the Ninth Circuit, we sort of had two different theories. One of our theories is that you cannot dismiss claims entirely on the state secrets privilege where the plaintiffs can make their own case. So, it's one thing if we don't have enough evidence, but if we have the evidence, and you're seeking dismissal because you say you're the one who doesn't need, who wants to use evidence, you can't get a dismissal on that basis. You can keep the evidence out if you want, but you cannot win a dismissal on that basis. And then our other argument was, as I mentioned at the outset, that because this is all electronic surveillance, this should be governed by the Foreign Intelligence Surveillance Act. And the Ninth Circuit actually accepted our second argument and ruled in our favor on that basis. Then there was a dissent from the denial of rehearing on bank signed by 10 judges, written by Judge Bumate, which I had mentioned, earlier, with the nearest reasonable referent canon in it, and then the court took it. So that's Fazaga in a nutshell. I think it's extraordinarily important for a bunch of reasons. It's a chance to hold the government accountable for discrimination that has just gone on ubiquitously against Muslim Americans for the last 20 years. It's also, I think, really important for people interested in the NSA spying and all this sort of mass warrantless surveillance, because the government their state secrets argument in our case is basically the same as their argument in their case, more or less. There's two remaining NSA lawsuits that have recently actually gone down on state secrets privilege, both of which I think the holdings are sort of directly sort of implicated by our FISA litigation. That's sort of, I could go on and on obviously about this, but that's sort of Fazaga in a nutshell.
Can I ask how you're thinking about arguing that case in terms of the Fazaga case, in terms of which justices you're trying to appeal to, who do you think is most in play? How does the sort of changed composition of the court change your approach as an advocate?
Yeah, I think one thing it does is our brief has a lot of history in it. There's a lot of discussion of the fact that the state secrets privilege never permits dismissals outside of the government contracting context ever. There's not a single case where it's ever happened. We trace that history going, Wigmore, Greenleaf, old evidentiary. We cite a bunch of British cases about this. There's also amicus briefs that are sort of solely devoted to that subject. Our FISA argument, we make a lot of textual arguments. We cite the dictionary again and again. We cite Scalia and Garner because actually they're really good arguments for our favor. I, on the one hand, as I was, talking with Cary, I sort of feel like I'm not sure how useful these are as tools of textual analysis. What you're trying to do is figure out what Congress intended in 1978. But there are very good arguments. If you take them at their face value, they're very good arguments that we have the better reading of the text. We have very broad language in our statute. So that's part of it. And then, I'm not sure this is a tactic, and we would have done this in front of any court, I think, but these are claims of religious discrimination. They really are. When the FBI, when this was all revealed, when the FBI acknowledged that they did use this informant, which they did in the district court, people were really hurt. It really, Ali Malik, one of our clients, he had this guy over to his house And his mom was cooking for him because he was trying to teach him the ways of Islam after this informant had, sworn an oath in front of 1,000 people in the mosque in Irvine, and, then was welcomed into that community. And that really matters. I actually think it really does. It's a terrible thing when it turns out that the government is lying to people in order to, and there's no criminal activity, right? There's no criminal, there's no convictions that arise out of this guy's time in Orange County. And so, I think we would have said that anyway, but I'm hoping that actually that does really matter to justices who, as we've talked about earlier, are very interested in religious discrimination.
Well, good luck, of course, with those oral arguments. We'll be watching closely and we're probably going to assign that oral argument to my students in con law next semester.
Oh, it's a lot of pressure.
We may be calling you for a little guest appearance.
Yeah, I don't know. I mean, I could talk about Gonzalo, but I don't know if we want to other things. I mean, I can't talk about the other case, but I'm not sure there are other things we want to talk about instead. It's up to you.
Well, we are running out of time. Let me at least take a minute. I think we'd be remiss if we didn't talk at least a little bit about the big Second Amendment case before the Supreme Court this coming term. It's a case called New York State Rifle and Pistol Association versus Bruin, NYSERPA is how it's often referred to. And this case involves a Second Amendment challenge to New York's discretionary permitting law for concealed carry of firearms. To get a concealed carry license to carry a concealed firearm outside of your home in New York, a person has to show proper cause, meaning that they have to have a special need for self-protection that's distinguishable from that of the general community. So the fact that you're fearing being a victim of crime, well, that's a very generalized claim. If you're actually being stalked by a particular person, or you carry a tremendous amount of cash or diamonds on your person as part of your job, well, those might be special needs that trigger a proper cause to get a concealed carry license. Two men and the New York State Rifle and Pistol Association challenged the law after New York rejected their concealed carry applications because they didn't have proper cause. Many of you know that in 2008, the Supreme Court in the Heller case said that the Second Amendment does protect an individual right to bear arms, but left many questions unanswered, including two that are raised in this case. The first being, does the right to bear arms extend outside the home? Do you have a right to carry a gun in public? Heller had a few words about that, but it was ambiguous and was not on the table in that case. And so that's a big question that the court's going to have to answer. And if it does extend outside the home, the right extends outside the home, can a state require proper cause permitting that effectively limits the number of people who can carry guns on the streets? Several justices have complained in recent years that the Second Amendment is being treated like a second-class right. That is to say that the courts are being too easy on gun laws and that courts should be raising the standard of review, making it harder for gun laws to survive under the Second Amendment. And it seems like the court now has the personnel to do that, to expand Second Amendment protections. Probably in this case, overturning discretionary permitting for concealed carry, and possibly too establishing a higher standard of review that would apply to other gun laws and make it harder for all gun laws to survive judicial review. To give you some perspective on what it might mean if New York overturns, if the Supreme Court overturns New York's discretionary permitting, Los Angeles also has discretionary permitting for concealed carry. And there are fewer than 400 people in LA County, a county of 10 million people, that have concealed carry permits other than retired police officers. In states that allow people to carry guns easily, they have shall issue permitting that doesn't give any discretion to the licensing authority about who can get a permit or not, as long as you're a law-abiding person, you've done the sufficient training. If a state requires training, then you can get a permit to carry a firearm. In those states that require a permit but give them easily, about 3 to 5% of the population ends up getting a permit and carrying guns on the street. In Los Angeles County, of course, if it's 3% to 5% of the population who gets a permit to carry firearms on the street, we'll go from having 400 people to 400,000 people. with licenses to carry firearms on the public streets of California or the public streets of Los Angeles. So the court, depending on what the court's going to do, and most commentators think the court's likely to overturn discretionary permitting, is likely to issue a rule that's going to require states to permit a lot more guns on streets like New York, Washington, D.C., where we have diplomats and foreign visitors and heads of states and government officials, and Los Angeles, San Francisco, and other states like that. One interesting aspect of this case is it sort of puts some of the originalists in a difficult position. We have a long history and tradition in this country of restricting concealed carry, including states that banned concealed carry in the 19th century. I'd be curious to see how the justices who claim to adhere to history and tradition in interpreting the Second Amendment will approach this issue, especially given the long history and tradition of both concealed carry restrictions and, importantly, judicial deference to lawmakers when it comes to gun safety. We'll have to see how that turns out. Curious if any of the panelists want to weigh in on the NYSERPA case.
Well, I will just say, as you mentioned, that this is another bite at the apple. The court had the opportunity in October term, I think it was either last term or the term before, to deal with NYSERPA versus the city of New York. And in that case, New York State repealed its law preventing the case from being heard on the merits. It was mooted out, and some argued that that was New York being advantageous, very strategic, whatever the reason. It provoked some serious consternation among some members of the court, including Justice Alito, who inveighed against the whole idea of all of this. It also prompted, I think, some consternation from Justice Thomas. In June of 2020, I think there were about 10 different cert petitions, all dealing with Second Amendment cases that were pending before the court, and the court declined to hear any of them, prompting a very impassioned dissent from Justice Thomas on the grounds that the court was playing fast and loose with the Second Amendment, and that if it were any other fundamental right, see abortion, the court would have been happy to protect these rights. Again, what a difference a sixth justice makes, what a difference a few months makes. And with the addition of Justice Barrett, suddenly I think there are those in the conservative wing who don't have to worry whether they will have Chief Justice John Roberts with them to form a majority of 5. They are assured of that 5-person majority, and suddenly we are seeing more movement on the Second Amendment.
So I just wanted to weigh in with one thing that we haven't talked about, and I just want to point out that we haven't talked about it, which is court reform. So if at the start of the year or after Biden's election, we had projected what would this Whither the Court be about, I think a lot of us would have said the prospect of court reform. There was all this talk of packing the court or jurisdiction stripping or all of those ideas. And we haven't mentioned it, and it has rather fizzled. I mean, there's a commission, they'll come up with recommendations, but it's clear that the administration is not prioritizing these kinds of reform matters, and we won't get a lot of movement there. But I just want to say it looks recently like all of this talk is starting to have some effect, because a number of justices are going on kind of PR tours now around the country saying, we're not partisan, we are objective, we don't decide according to our politics. Partly that's in response to the court reform talk, partly that's in response to 40% approval rating. The Supreme Court has really plummeted, especially after what it did in Texas in its approval rating. It's always enjoyed a pretty high approval rating. Now it has sunk down pretty low, and the justices are concerned about that public perception. So I just want to say that going forward this year, one of the things that I think is going to be really interesting to look at is what effect that has. Does it have an effect where the Chief Justice's institutionalism prevails, and in some cases you get a little bit of brakes being put on, or does it encourage the court to do more in a kind of shadowy kind of way? Gut Smith, don't overrule it. Completely gut row, don't overrule it. Do more on the shadow docket. So you get your agenda and you don't really put the brakes on, but you do it in a way that journalists can't really follow and that we don't have big headlines. That's one thing I'll be looking at this coming term and this coming year. where are we going with this?
Well, that's a great place for us to end as we anticipate the coming term of the Supreme Court. We are at the end of our time of our panel for Whither the Court. Thank you again to all our panelists and especially to Professor Melissa Murray. Thank you so much. I know it's a hardship for you to make the time for this, and we really, really appreciate you being here. And thank you to everyone for logging in.
Thanks very much.